Welcome to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoy the show, which features immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer International Edition. You have questions? We've got the answers.
Good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Yes, 2025. 2024. Everything is shaping up for 2025 when Trump takes office. Again, obviously, the biggest issues for him is immigration and other issues that he promised in his campaign that he is supposed to keep. The stock market is going up, so they believe that another Trump term may mean more profits for businesses and for individuals. Well, the verdict will be out, I guess, later on. So whether it be the taxes that are going to be put on goods that we consume, most consumers, we have to compartmentalize, the impact that this victory for Trump, what it's going to have on the economy, what it's going to have on the law, what it's going to have on your lives. So whether it be Latinos from Mexico, Latinos from Puerto Rico, Latinos from South America, they were part of the winning formula for Trump. I guess these communities, like the black community, they are concerned that immigrants are coming across the border and taking their jobs on the farms, taking their jobs in the factories, the meat factories, the poultry farms. And is that really true? Is that the job you want to keep? Obviously, the more technology that we have for jobs that are labor intensive or dangerous by repetition or the environment that you work in, most people do not want those jobs. And most times new immigrants to America, whether they're white, whether they're black, whether they're Latino, most times those immigrants historically coming in from Italy, coming in from the Irish coming into America, the Chinese coming into America, those various groups were obviously taking the jobs that most Americans didn't want, which they shouldn't want if they really want good economic development. Tesla, the guy with the richest man in the world, what does he want to do? Well, he wants his robo-taxis. Who drives Tesla cars? Who's going to be driving those cabs? No one. Who's going to lose jobs? Taxi drivers. Who are the people that actually drive taxi cabs almost every day? They're black, they're Latino, they're Eastern Europeans. Yes. What type of jobs are they going to get if they no longer could drive a car because it's a robo-taxi? Does the gentleman from Tesla care? Obviously not. He's going to maximize his profit. So when you hear different people endorsing different candidates, they do so for economic reasons for themselves. But how about the greater society? So a lot of people, you know why they drive a cab? They might be in college. Why do they drive a cab? It's their full-time job. So there are various reasons that people may become a cab drivers. A lot of immigrants, when they come to the country, they drive it. Why? English is their second language. Or there are people who live in this country all their life in the Latino community, Mexicans, Puerto Ricans, and they never learn English. And how do they integrate into the what? Job market. So these are issues when you should listen to, I would say, quality debates, and you don't get quality debates. People vote, obviously, by their passion. And then eventually, what does passion get you? My name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. So what do lawyers do? They listen. They listen to the facts, apply it to the law to determine whether or not you obviously, qualify for a particular benefit or what arguments that will be made on your case. So if it's like immigration matters, obviously, how do you get onto that path for citizenship? Do you qualify for bankruptcy? Do you qualify for equitable distribution in a divorce? So listening is important. Analyzing is important. And that's what we do at the law firm of Figueroa & Associates, located in Brooklyn, New York. Again, my name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. In modern times, and when I say modern times, I mean post-pandemic, or we still in the pandemic, or post-COVID, we still have COVID. But what hasn't changed is virtual appearances. So in immigration court, the Supreme Court, and civil court, attorneys are still making what we call virtual appearances via Zoom. So you sit in your attorney's office, and he logs in through the system, and the judge and other attorneys are there, and they listen to arguments in your particular cases. So, for example, this morning, I was on immigration court. So the client had a master hearing. That's the first hearing that you have before you have your individual hearing, your merits hearing. So the judge reviewed the case today, gave one more deadline 30 days before the trial date, and the trial date was set for November 1st, 2027. Oh yes, you're hearing right. November 1st, 2027. Today is November what? 2024. So what we have is a 3-year delay because there's backlog in the courts already. So when President Trump talks about backlogs or mass deportations, what is he going to do? Well, he could put troops on the border, police officers on the border. That would stop, people from coming in. But how about people who have been here, the 25 million that he has spoken about? When and how is he going to apprehend these people, and what is going to happen in the court system? Trump knows that he cannot solve these issues in his 4-year term. He's been there, done that, didn't achieve anything. What is going to happen, like his first term in office, promises made are not going to be promises kept. Why? Because it's legally impossible, it's fiscally impossible, and he knows this. He sits with his advisors. They tell him, well, look, you could say this, you could say that. Let's create a deficit. Trump is not going to be around when you have to pay all the debt that he is creating in his administration. Trillions of dollars. Yes, trillions. 1,000 billion is a trillion, if my, math is whatever correct. So So he's going to create trillions of dollars in debt, and who's going to pay for it? Your kids, your grandkids, your great-grandkids. If you've seen pictures of the president and his son, who's 18 years old, they don't have to worry about that. They have accumulated wealth. They have wealth for generation to generation. Tesla, wealth, generation to generation. Their reality is not you, the listenership reality. It is probably not the reality of 95% of Americans. But we go to the polls, whether it be local elections, municipal elections, federal elections, and we vote for people who actually cannot solve a problem, have never solved a problem, and the voters, you believe you're in a democracy. Yeah, you're in a democracy, but what does that mean? Are you intelligent enough to vote? Are you listening to the debates, if there's any? Are you calculating or researching using ChatGPT what these elected officials promise you? Do you know what ChatGPT is? Well, ChatGPT is a good emancipator for the ignorant, meaning if you lived in ignorance all your life, this is the opportunity to use ChatGPT to do research on the promises that elected officials make. Your boss tell you something to do on the job, you don't know how to do it. For kids in elementary school, middle school, high school, universities, ChatGPT is the equalizer and the emancipator. So whether it be Kamala, who lost, or Trump, who win, who was the most truthful one? Who made promises that are actually going to be kept? And at the end of the day, what type of voter are you? One motivated by, what do you call that? Emotions, or one motivated by intelligence? When you listen to our radio show, we explain. We obviously, when we meet with clients, they explain their issues. We analyze. That's the approach that has to be made. But if you lack the education to analyze, or you use social networks to make decisions, then something is definitely wrong with you. Because whether it's be you, your children, or your grandchildren, you, 90% of Americans, are the ones who will suffer. Again, my name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. Give us a call at 855-768-8845. Go to our website at www.askthelawyer.us. Again, www.askthelawyer.us. Schedule a consultation. Come in, let's talk about your legal issues. Whether it be immigration, matrimonial matters, bankruptcy issues, debt issues, wills, trusts, and estate planning, personal injury issues, give us a call.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figueroa and Associates, your trusted partner in U.S. immigration law for religious workers. Call Figueroa and Associates today.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figueroa and Associates, your trusted partner in U.S. immigration law for entertainers.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Don't get deported. Green card lottery. Undocumented individuals' ineligibility and scam risks. The following is an analysis of the current green card lottery system. If you are undocumented in the U.S., you are most likely not eligible. Be careful of lottery scams that can get you deported by notaries or lawyers. The Diversity Immigrant Visa, DV, program, often referred to as the Green Card Lottery, is one of the United States' most distinctive immigration initiatives. It provides individuals from countries with historically low rates of immigration to the U.S. the opportunity to secure lawful permanent resident status. Each fiscal year, up to 55,000 immigrant visas are made available through this program. This analysis explores the structure, purpose, challenges, and implications of the Green Card Lottery, with a particular focus on its impact on individuals both inside and outside the United States. Additionally, this report addresses the significant issue faced by individuals in the U.S. who have overstayed their visas. Such individuals, unless grandfathered under Section 245 of the Immigration and Nationality Act, INA, face significant legal hurdles in adjusting their status while remaining in the U.S. If they depart, they may be subject to a 3 or 10-year bar from reentering, further complicating their immigration journey. History and purpose of the Green Card Lottery. The DV program was established by the Immigration Act of 1990 to diversify the immigrant population in the U.S. At its core, The program aims to balance migration by encouraging individuals from underrepresented countries to apply. For many, it offers a rare opportunity to achieve the American dream without the traditional pathways of family reunification, employment sponsorship, or asylum. Key milestones in the history of the DV program include 1. Legislative foundation. Congress implemented the lottery to address imbalances created by previous immigration policies favoring family and employment-based immigration. 2. Annual allocation. Each fiscal year, 55,000 visas are allocated to applicants from eligible countries. 3. Global outreach. Countries that have sent more than 50,000 immigrants to the U.S. in the past 5 years are ineligible, ensuring a broader geographic distribution. The Green Card Lottery serves as a beacon of opportunity for many, but it has its share of complexities and criticisms. Eligibility and application process. The program has a relatively straightforward application process, though the eligibility criteria are strictly enforced. 1. Eligibility requirements. Applicants must be from eligible countries with low immigration rates to the U.S. They must have at least a high school education or equivalent, or 2 years of qualifying work experience. 2. Application procedure. The application is submitted electronically via the official DV program website. The process is free, though applicants should beware of fraudulent services. 3. Selection and notification. Winners are selected randomly by a computer-generated lottery. Being selected does not guarantee a visa, as winners must meet all eligibility and admissibility requirements. While the program seems simple on the surface, logistical and legal challenges often arise, especially for individuals residing unlawfully in the U.S. Challenges for overstays and adjustment of status. One of the most significant legal hurdles for certain green card lottery winners is the inability to adjust status within the U.S. if they are out of status. Understanding this issue requires a closer examination of INA Section 245(e), the 3 and 10-year bars, and the consequences of overstaying a visa. INA Section 245(e), grandfathering provision. Section 245(i) allows certain individuals who are ineligible to adjust status within the U.S. to still apply for adjustment if they meet specific requirements. Grandfathering. To qualify, the individual must have been the beneficiary of a qualifying immigrant petition or labor certification filed on or before April 30, 2001. Penalty fee. Applicants under this provision must pay a $1,000 penalty fee. However, most overstayers today do not qualify under 245(e), as the deadline for filing was over 2 decades ago. As a result, these individuals must leave the U.S. to process their immigrant visas at a U.S. consulate abroad, which triggers the 3 or 10-year bar. The 3 and 10-year bars. Under INA Section 212(9)(b), individuals who accrue unlawful presence in the U.S. face significant penalties upon departing the country. 3-year bar applies to those who have been unlawfully present for more than 180 days but less than 1 year if they leave the U.S. voluntarily before removal proceedings are initiated. 10-year bar applies to those who have been unlawfully present for 1 year or more. These bars are particularly problematic for green card lottery winners residing unlawfully in the U.S. because 1. They cannot adjust status within the U.S. without the protections of 245(e). 2. Departing the U.S. to complete consular processing triggers the bar. Impact on DVE lottery winners. For DVE lottery winners who are ineligible for adjustment of status, they must carefully weigh the risks of triggering the 3 or 10-year bar. In some cases, they may seek a waiver of inadmissibility, though these waivers are difficult to obtain and subject to strict criteria, including demonstrating extreme hardship to a U.S. citizen or lawful permanent resident family member. Broader implications for U.S. immigration policy. The green card lottery system and the challenges faced by overstayers highlight broader issues in U.S. immigration policy. 1. Systemic inconsistencies. The lottery promotes diversity but does not address the needs of individuals already contributing to U.S. society. Overstayers, many of whom are integrated into their communities, face legal barriers that undermine the lottery's inclusivity. 2. Policy gaps. The lack of a contemporary equivalent to 245 BAI leaves many without viable options for legalization. The 3- and 10-year bars create a punitive system that discourages compliance. 3. Humanitarian concerns. Families are often separated due to the bars, leading to emotional and financial hardship. Immigrants who contribute to the economy and society are unable to regularize their status. Calls for reform. The Green Card Lottery, while innovative, is not without its detractors. Critics argue that the program 1. Fails to address broader immigration needs. It provides opportunities for new immigrants but does little to address the status of undocumented individuals already in the U.S. 2. Lacks modernization. The program's reliance on random selection overlooks merit-based considerations. 3. Exacerbates vulnerabilities. Selected individuals residing unlawfully in the U.S. faced unique challenges, including the inability to adjust status and the risk of triggering bars. Proposed reforms. Policymakers and advocates have proposed several reforms, including reinstating or updating 245(p) to allow more overstayers to adjust status, reducing or eliminating the 3- and 10-year bars for individuals with strong ties to the U.S., transitioning the DV program to a hybrid model that incorporates both diversity and merit-based selection. Case studies and real-life scenarios. To illustrate the challenges faced by Green Card lottery winners, consider the following hypothetical scenarios. 1. Maria from El Salvador. Maria overstayed her visa in 2005 and has lived in the U.S. for nearly 2 decades. She wins the DV lottery but cannot adjust status because she is not protected by 245(e). Departing to complete consular processing would trigger a 10-year bar, leaving her family in the U.S. without her. 2. Ahmed from Yemen. Ahmed wins the DV lottery while visiting the U.S. on a tourist visa but overstays after applying. Although eligible for the lottery, his overstay prevents him from adjusting status. Facing the 3-year bar, Ahmed decides not to pursue his visa, missing his chance for permanent residency. Conclusion and recommendations. The Green Card Lottery is a valuable program that promotes diversity and provides opportunities for individuals worldwide. However, its impact is undermined by systemic barriers faced by those unlawfully present in the U.S., particularly overstayers who cannot adjust their status without leaving the country and facing punitive bars. Addressing these issues requires comprehensive immigration reform, including revisiting and expanding Section 245(e) to provide more pathways for adjustment of status, reducing or eliminating the 3- and 10-year bars for individuals with strong U.S. ties, modernizing the Green Card lottery to align with contemporary immigration needs and challenges. By addressing these shortcomings, the U.S. can make the DV program more equitable and effective, ensuring it fulfills its promise of opportunity and diversity for all.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figaro and Associates, your trusted partner in student visa success.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figaro and Associates, your trusted partner in U.S. immigration law for religious workers. Call Figaro and Associates today.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Our weekly immigration news roundup is brought to you by the law firm of Figaro and Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
President Donald Trump's proposals to eliminate birthright citizenship and implement mass deportations of undocumented immigrants sparked intense debate over their legality, feasibility, and implications. Birthright citizenship, rooted in the 14th Amendment to the U.S. Constitution, guarantees citizenship to anyone born on U.S. soil, regardless of their parents' immigration status. Meanwhile, mass deportations of millions of undocumented immigrants present logistical, ethical, and legal challenges. This article explores the legal pathways and obstacles to implementing these controversial policies, examines historical and contemporary precedents, and analyzes potential consequences on the social and political fabric of the United States. 1. Birthright citizenship, legal framework and challenges. Overview of birthright citizenship. The principle of birthright citizenship in the United States is codified in the 14th Amendment, which states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." The phrase "subject to the jurisdiction thereof" has been central to debates about whether children born to undocumented immigrants qualify for automatic citizenship. Supporters of birthright citizenship argue that this interpretation was settled by the 1898 Supreme Court case United States against Wong Kim Ark, which upheld the citizenship of a child born to non-citizen parents who were lawfully present in the U.S. President Trump's proposal. President Trump suggested ending birthright citizenship through an executive order, bypassing Congress. He argued that birthright citizenship incentivizes unauthorized immigration and that the children of undocumented immigrants, often termed anchor babies, unfairly benefit from automatic citizenship. Can birthright citizenship be revoked? 1. Executive action. Legal feasibility. Ending birthright citizenship via executive order faces significant constitutional hurdles. Constitutional amendments cannot be overridden by executive authority. Courts would likely strike down such an order as unconstitutional. Judicial interpretation. Advocates of this approach argue that the Supreme Court could reinterpret the "subject to the jurisdiction thereof" clause to exclude children of undocumented immigrants. However, this would require a radical departure from established legal precedent. 2. Legislative action. Proposed legislation. Congress could attempt to pass a law redefining the scope of the 14th Amendment's Citizenship Clause. Such a law would likely face immediate legal challenges and could be struck down by the courts as unconstitutional. Constitutional amendment. The most definitive way to end birthright citizenship would be through a constitutional amendment. This would require approval by 2/3 of both houses of Congress and ratification by 3/4 of state legislatures, an extremely difficult political feat. Challenges to implementation. 1. Legal precedent. The Wong Kim Ark decision firmly establishes that birthright citizenship applies broadly. Overturning this precedent would require a Supreme Court ruling explicitly narrowing the interpretation of the 14th Amendment. 2. Public opinion and political opposition. Public support for birthright citizenship remains significant. Attempts to eliminate it would likely face widespread opposition from civil rights groups, immigrant advocacy organizations, and political opponents. 3. Practical implications. Eliminating birthright citizenship could create a large population of stateless individuals, as many children born in the U.S. would lack citizenship from any country. This could lead to legal limbo and significant human rights concerns. 2. Mass deportation of undocumented immigrants. Legal and logistical challenges. President Trump's mass deportation policy. During his presidency, Trump called for the removal of all undocumented immigrants, estimated at over 11 million people. His administration implemented policies like enhanced immigration enforcement, expanded detention facilities, and increased deportations. However, a full-scale deportation plan poses significant challenges. Legal authority for deportations. 1. Immigration and Nationality Act, INA. The INA provides the legal framework for immigration enforcement, including the removal of individuals who enter the U.S. without authorization or overstay their visas. Deportation requires a formal legal process, including a hearing before an immigration judge. 2. Expedited removal. Expedited removal allows certain individuals to be deported without a hearing if they are apprehended near the border and cannot prove lawful entry. Trump sought to expand the use of expedited removal, but this approach has limitations under due process protections. 3. Executive orders and memoranda. The Trump administration issued executive orders prioritizing the deportation of undocumented immigrants, including those without criminal records. However, these orders cannot override due process rights guaranteed by the Constitution. Challenges to mass deportation. 1. Legal constraints. Due process. The Fifth Amendment guarantees due process rights to all persons in the U.S., including undocumented immigrants. Mass deportations would require individualized hearings, making rapid removal of millions legally unfeasible. Judicial backlog. Immigration courts are already overwhelmed, with hundreds of thousands of pending cases. Expanding deportations would exacerbate these delays. 2. Logistical and economic feasibility. Cost. Estimates suggest that deporting all undocumented immigrants could cost between $100 billion and $300 billion, considering enforcement, detention, legal processing, and transportation expenses. Manpower. Immigration and Customs Enforcement, ICE, and Customs and Border Protection, CBP, lack the resources to carry out mass deportations on such a scale. 3. Social and economic consequences. Impact on families. Many undocumented immigrants have U.S. citizen children, leading to family separations and psychological trauma. Economic disruption. Deporting millions would disrupt industries reliant on immigrant labor, such as agriculture, construction, and hospitality. 3. Political and public challenges. Partisan divide. Immigration policy has become a deeply polarized issue in American politics. While some Republicans support Trump's proposals, Democrats and moderate Republicans generally oppose them. Achieving legislative or constitutional changes would require bipartisan support, which is unlikely given the current political climate. Public opinion. Polling on immigration issues reveals a divided public. 1. Birthright citizenship. Most Americans support maintaining birthright citizenship, viewing it as a cornerstone of national identity and equality. 2. Mass deportations. Widespread opposition exists to mass deportations, particularly among younger generations and minority groups. International relations. Mass deportations and the elimination of birthright citizenship could strain relations with countries of origin for undocumented immigrants. Deporting millions of individuals to countries like Mexico, Guatemala, and El Salvador could overwhelm their social systems and damage diplomatic relations. 4. Alternatives and recommendations. Comprehensive immigration reform. Rather than pursuing policies of mass deportation or eliminating birthright citizenship, comprehensive immigration reform offers a more viable solution. Key components could include pathways to legalization, providing a path to citizenship for undocumented immigrants who meet specific criteria, such as long-term residence, employment, and clean criminal records. Enhanced border security, balancing enforcement with humane treatment of migrants. Modernizing the immigration system, streamlining visa processes and reducing court backlogs. Targeted enforcement, focusing enforcement efforts on individuals with serious criminal records rather than implementing blanket deportations would address security concerns without overwhelming the legal system. Conclusion. President Trump's proposals to eliminate birthright citizenship and implement mass deportations face insurmountable legal, logistical, and ethical challenges. Both policies would require constitutional, legislative, and procedural changes that are unlikely to succeed given current legal frameworks and political realities. Rather than pursuing divisive and legally fraught measures, policymakers should focus on comprehensive immigration reform that addresses the root causes of unauthorized immigration while respecting human rights and constitutional protections. Only through balanced and practical solutions can the U.S. effectively manage immigration in a way that upholds its values and national interests. Immigration law is complex. Have questions about immigration? Ask the lawyer. Call 855-768-8845 or visit askthelawyer.us to schedule an appointment. The lawyer you hire does make a difference.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa & Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Estate planning is a necessity, not a luxury. Let the law firm of Figueroa & Associates help you protect your legacy, assets, and loved ones. Get estate planning consultation on wills, living trust and probate, power of attorney, health proxy, deed transfers, providing for special needs, disabled children and grandchildren, minimizing federal and state taxes. Call us right now at 855-768-8845. That's 855-768-8845. Or schedule an appointment at www.askthelawyer.us. That's www.askthelawyer.us.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Visiting the United States is a dream for many around the world. Whether you want to explore iconic landmarks like the Statue of Liberty, experience American culture, or visit friends and family, the first step is securing a U.S. visitor's visa, known as a B-2 visa. The process can seem daunting, especially for someone living overseas. However, with proper preparation and understanding of the process, it's possible to navigate it successfully. This article will provide a step-by-step guide on how to apply for a U.S. visitor's visa from overseas, along with tips to improve your chances of approval. Understanding the U.S. visitor's visa B-2. The B-2 visa is intended for those who wish to enter the United States temporarily for tourism, vacation, or medical treatment. It's classified as a non-immigrant visa, meaning you are expected to return to your home country after your stay in the U.S. B2 visa holders are permitted to visit tourist attractions, national parks, and other landmarks, attend cultural or sporting events, visit family or friends, receive medical treatment, participate in short recreational courses, as long as it's not for credit toward a degree. It's important to note that working, studying, or living permanently in the U.S. is not allowed under the B2 visa. Step-by-step application process for a U.S. visitor's visa. Step 1. Determine your visa type. Before beginning the application, it's important to ensure that a B2 visa is the right one for your intended purpose. If you plan to travel to the U.S. for tourism, visiting family, or medical treatment, the B2 visa is likely appropriate. Step 2. Complete the DS-160 form. The DS-160 form is the online non-immigrant visa application form, which is mandatory for all visitor visa applicants. The form collects information about your personal details, travel plans, and background. Where to apply? Visit the Consular Electronic Application Center (CEAC) website to fill out the form. Documents you need: passport details, travel itinerary, and dates of your 5 previous visits to the U.S., if applicable. You'll also need a digital photo that meets specific requirements, including size and quality. Accuracy is key. Make sure every detail is accurate and honest. Any discrepancies could lead to delays or denial of your visa application. Step 3. Pay the visa application fee. After completing the DS-160 form, you'll need to pay a non-refundable application fee. As of 2024, the fee for a B2 visa is $185 USD, but it's advisable to check the official U.S. Department of State website for the most current fee structure. How to pay? Payment methods vary by country, but most consulates allow online payment through a credit card, bank transfer, or local payment systems. Save the receipt. Once payment is made, save the receipt as it will be required during your visa interview. Step 4. Schedule your visa interview. After paying the visa fee, you must schedule an appointment for a visa interview at the U.S. Embassy or consulate in your country. The wait time for an appointment can vary by location, so it's recommended to book as early as possible, especially during peak travel seasons. Where to schedule? Visit the U.S. Embassy or consulate website in your country to schedule the interview. Some locations may allow scheduling by phone or online. Wait times. In certain countries, the waiting time can range from days to months. It's wise to check the consulate's website for current wait times and plan accordingly. Step 5. Prepare for your interview. The visa interview is a critical step in the application process, as the consular officer will determine whether you qualify for a visitor's visa. Documents to bring: a valid passport, the DS-160 confirmation page with the barcode, proof of visa fee payment, your appointment confirmation letter, a passport-sized photo if your photo upload failed on the DS-160, financial documents proving you can afford the trip and will not need public assistance in the U.S., evidence of ties to your home country, job contracts, property ownership, family ties, to show that you intend to return after your visit. Any relevant travel plans, such as hotel bookings or invitations from family or friends in the U.S. Interview questions to expect. During the interview, be prepared to answer questions about your reasons for visiting the U.S., how long you intend to stay, and your financial means to support your trip. It's essential to convey that your visit is temporary and that you have no intention of overstaying your visa. Step 6. Attend your interview. Arrive on time for your visa interview, dress neatly, and bring all required documentation. The interview typically lasts between 5 and 15 minutes. The consular officer will ask you questions to assess your eligibility for a visitor's visa. Common questions: why do you want to visit the U.S.? How long will you stay? Do you have family or friends in the U.S.? What do you do for a living? Be honest. Answer all questions truthfully. Any signs of dishonesty or inconsistencies can lead to your visa being denied. Possible outcomes. After the interview, the officer will inform you whether your visa is approved or denied. If approved, you will be informed of when and how you will receive your visa. In some cases, additional administrative processing might be required, which can extend the decision-making period. Step 7. Visa approval and travel. If your visa is approved, it will be placed in your passport, and you can use it to travel to the U.S. It's important to note that a visa does not guarantee entry into the U.S. The Customs and Border Protection (CBP) officer at the port of entry has the authority to admit or deny your entry. Tips for a successful visa application. Applying for a U.S. visitor's visa can be complicated, but following these tips can improve your chances of approval. Provide strong evidence of ties to your home country. Consular officers want to be assured that you will return to your home country after your visit. Be prepared to present proof of employment, property ownership, family responsibilities, or other factors that demonstrate your intention to return. Have a clear travel plan. You should have a well-organized itinerary for your trip. If possible, provide hotel reservations, tour bookings, and details of the places you plan to visit. Financial readiness. Demonstrate that you have sufficient funds for your trip. Bank statements or financial documents can help prove that you can afford your stay in the U.S. Be honest and consistent. During your interview, answer all questions truthfully and consistently. Any signs of deception or discrepancies between your answers and the information on your DS-160 form could lead to a visa denial. What to do if your visa is denied? Visa denial can be disappointing, but it's not the end of the road. If your visa application is denied, the consular officer will give you a reason for the denial. The most common reasons for denial are inadequate proof of ties to your home country, inconsistent or incomplete documentation, concerns about your financial stability. If denied, you can reapply by addressing the issues that led to the rejection. However, you will need to pay the visa application fee again. Applying for a U.S. visitor's visa from overseas can be a complex process, but careful preparation and adherence to the guidelines can greatly improve your chances of success. Ensure that your documentation is accurate, your ties to your home country are well documented, and you are honest throughout the process. Once your visa is granted, you'll be able to enjoy your trip to the U.S. with peace of mind. If you need legal assistance with your visitor's visa application, it is important to consult with an experienced attorney. The law firm of Figaro and Associates, which has over 25 years practicing immigration law, and can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hired does make a difference.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.